because it was an important contract for Thales. I knew about its signature at the time it was signed. And later on, I was a little bit more involved in that deal in the way that we had inside of there was a consortium which was the contractor to the South African authority, and we had a dispute between the member of the consortium, and specifically Thales had suffered some delays, and they wanted to get from the German company some compensation for the delay that they were responsible for. So there was an arbitration in Switzerland about those technical problems which arise from cabling and things like that. So I was supervising that arbitration. One of the lawyers of my team was more involved than I was, but since she was a junior, I had to advise her on many things, and I followed that arbitration. So I had more information about the way it has been, the contract was structured, and later on. In 2003, I became in charge of the investigation which were going on in South Africa. Previously, there was another person who was in charge, but he left his position to another one, so I took over his duties in that, and so from March 2003, I became more involved in that matter.
Right. In 2003, you became involved in the investigation that was taking place in South Africa to the arms acquisition. Now, we'll revert to that later. In paragraph 6 at page 2 of the statement, you allude to the fact that some of the events that took place around the arms acquisition in South Africa, you do not bear personal knowledge thereof. However, you are competent and authorized to testify about that. Can you just indicate to the Commission as to what your source of information is, and regarding the basis? I think you've already laid the basis because you are in the legal department of Thales. Please proceed.
Yes, so when we started, when I was not involved in directly involved before 2002, when we started the dispute with the German frigate consortium. But of course, I talked to the people who were involved in the negotiation. I talked to the people who were involved in the negotiation in South Africa as well as in France.
At paragraph 8, you are actually explaining as to why it is that you are the person that is competent to give evidence, and why so many other people that were perhaps involved cannot testify.
Yes, in fact, it was a long time ago, so most of the people have now left the company, mostly for retirement, and they are, most of them, no longer into the Thales radar, I would say. And so from what I know, there is no one in the company who has such an extensive knowledge as I am, which explains why I'm here.
In paragraphs 9 to 15, which appears on pages 3 to 4 of your statement, you are outlining the business as well as the history of the company. Now, will you please inform the Commission as to what the business of the company is?
excuse me. Thales is involved in many different activities, and defense is one of them. Our turnover is about 50% defense, but otherwise we are present in aeronautics space. We are manufacturing satellites. And sending satellites into space. Aeronautic, we are doing a lot of things in the cockpit of aircraft, Airbus, for example. We are doing air traffic management. I think that in South Africa we have did a lot on that. And we are doing transportation, signaling transportation. That means that railway signaling. And what else? And a lot of security as well, meaning secured communication. I think that 80% of the bank are using our encrypted connection just to prevent hackers to enter into the bank system.
In your evidence, you mentioned, amongst others, that Thales has done air traffic management for South Africa or in South Africa a lot. Can you just indicate to the Commission as to whether this service was only rendered after the advent of the arms acquisition process, or is it the service that has been rendered to the Republic of South Africa over time by this company?
I believe that Thales, its former name Thomson CFF, was well known from South Africa. We have been present in the early 60s. Of course, during the period where the embargo, we did not have so much dealings, but we have been present all over this year and well known to the South African country.
Now, I'd like to take you to paragraphs 13 to 15 of your statement, where you are outlining the history of the Thales Group. Will you please proceed to present that evidence to the Commission?
Yeah, Thomson CSF is known, but in fact it's started by the end of the 19th century. That a company which was called Compagnie Française Thomson Houston was created in France. It was originally created in the United States, and they decided to move to France. And then it acquires quite a lot of other company, and not in particular a company which was called Compagnie Sans Fil, CSF, and these companies were mainly dealing with radar, military as well as civilian, and communication. So it's the story of Thales is communication.
Right. You mentioned in paragraph 15 of your statement that in 1998 the company was privatized. Now, can you just shed light to the Commission as to whether at the time when the invitation to send information or show interest in participating in the acquisition, when that was done, whether by that time the company was already privatized or it had not as yet been privatized?
It's not yet been privatized. The privatization process started in 98, and before that, Thomson CSF was 100% owned by the French government.
Right. Thank you. Then let us turn our attention to the following paragraphs dealing with the Thales Group and South Africa. Now, will you please just outline the the relationship between the Republic of South Africa and Thales over the period prior to the sanctions around the 70s, and then you take us through to later on and up to the time when Thales then started participating in the arms acquisition.
So I know that in the early 60s, Thales Thomson CSF at the time had entered into contract with South Africa for providing South Africa with weapon systems, and that was developed with funding from South Africa. And then that was early 60s, I think. And then later on continued to provide services in air traffic management, radar, and of course when the change occurred in South Africa, the embargo.
Right. You mentioned in paragraph 18, right towards the bottom that of that paragraph, that your company was one of the relatively small pool of international manufacturers with the capacity and ability to assist the countries, specifically in the context of the statement with the combat suites and so forth. What is the basis on which you make the statement?
Since I've been with Thales such a long time, I know rather well the market, Thales market, and as well as the competition in that market, because we are facing that competition all the time. So we know that there are companies in the US which have experience and can provide modern system, but in Europe we do have competitors like the British with BAE system. We do have in Germany, there are some other companies which have the ability to address international market. And then between the Europe, US, you have Russia, of course, who has the capacity, but during the period between 1989 to maybe today, Russia has been just struggling with its own problem and is not as much a competitor than it was in the early 80s. So we all know who are our competitors in the military market. It's a very small market that could have that ability, and we know that we can deliver internationally systems.
Now, in paragraph 19, you are talking about resuming the relationship, especially with regard to armament acquisitions with South Africa. And that's when you mention the acquisition of shares with ADS. Now, other than ADS, which was then known as Altec Defense System, are there any other companies that were approached by Thales for the purpose of establishing a commercial relationship with, in particular, with relation to armament?
I know at least that Thales was at some point interested in Denel. I'm not sure that it was a whole Denel company, but I think that Denel has many businesses, and at least there is one business which is in the military. Right.
In the following paragraph, you just reiterating that, because of the relationship that had been in existence with South Africa, there was no need to get an introduction to the South African market.
No, I think that Thales was well known from the South African people, and of course, since Thales was also a French government-owned company, it was easy to access through the diplomatic channel as well.
Now, please turn over to page 6. Now, in paragraph 23, which appears on page 6, you are dealing with the shareholding acquisition and the focus of ADS, as well as the capabilities of ADS. Now, could you please just place this evidence before the Commission, and also dealing with the question as to whether C squared to I squared, do you know whether it also had such capabilities or not as ADS?
ADS was comparatively to Thales a rather small company, but it was very well implanted in South Africa in the defense market, and I've been working with Armscor over the years. So was a company who had already proven its ability to deliver a system to the South African military, and I can't recall the name of the company. I know it, but it's difficult for me just to pronounce. But the other company, as far as I understand, was smaller, had not such an extended experience than ADS, but could have been a subcontractor also.
Right, in paragraph 25, you're talking about the defense review and what it sought to do, and that your company saw opportunity in the exercise, an opportunity to perhaps also conclude transactions or participate in the conclusion of transactions with the Republic of South Africa. And then in paragraph 26, you are alluding to the fact, which is also well known in the Commission, that you were invited to furnish information or show interest into the arms acquisition by South Africa. Do you know as to whether this invitation was solicited through any other improper means?
I'm not aware of any other channels that could have asked Thales to participate in that request for proposal.
Now, you mentioned that Thales in paragraph 26, page 27, I beg your pardon, paragraph 27, page 7, you mentioned that Thales was well familiar with the acquisition processes, and because it had been exposed to different contracting models and processes. Now, is there anything that you'd like to add to that, or in order to illustrate to the Commission?
So Thales has been involved in a lot of international procurement process. We had delivered, of course, a lot of equipment to the French military, but not only the French, to the Indian, Iraq, US, of course in Europe, to Italy, Spain, Germany, and Saudi Arabia, UAE. I don't know. There are a lot of opportunities that we acquire experience in large contract and large procurement contract.
Now, in paragraph 28, you are dealing with the issues of liability. It is common knowledge that the prime contractors would be held liable for any malperformance or underperformance or defective performance in relation to the contracts. What measures or cautionary measures did you take in order to mitigate exposure to the risk of that type of liability?
Of course, the South Africa wanted to have only one contractor in Fasosim, but if it's such a large program, it's quite usual to form consortium, and and inside the consortium, because we are jointly and severally liable to the government, we have a special consortium agreement where we divide the liability between the consortium members. And so it was quite usual for Thales to work in that way. So we don't want to be responsible for the bad works made by one of the member of the consortium, so we can go after him if we are not satisfied. That's what we did, for example, against the German companies. We were not satisfied. There was, of course, the delay mean that there would be large penalties to pay to the South African government, and we don't want to be to have to pay those penalties if we were not responsible for the delay. So there is always a mechanism where you can go after the other if you think that they are the one who are at fault. And but of course it doesn't involve the government of the country. It's between ourselves. It's a commercial contract that we have between ourselves.
Now, will you inform the Commission as to how it came about that you then established this consortium, which came up to be known as the German Frigate Consortium, GFC?
Yes, there are various models of acquisition in the world, and most of the time the government would want to have only one person in front of him. It could be that there is a prime contractor, and and the prime contractor subcontract to others. Of course, Thales doesn't manufacture ships. So it would not provide. It could have been a way to deal with that Thales would provide the ship and would subcontract the manufacturing of the ship to others. But it has been, I think, some negotiation to find out what would be the best model, best way to promote this equipment, because of course one of the main subject matter with that kind of procurement is the price. So you have to find the best way to minimize the risk and to have the best price, because there is competition. So if you want to win the contract, you have to try to find the best solution that you can have the best price, the price which meets the government requirements, of course, and the budget. Most of the time there is a limited budget in the country. So you try to figure out what would be the best way to meet the expectation of the government, as well as your own risk and liabilities, because you want to be on time. So that means that, because otherwise you could face penalties or even termination of contract. So it's really weighting the balance and see what is the best solution for the company who are interested in the deal.
And what prime role did you see yourself or expect yourself to play in this acquisition program?
So Thales' expertise is in electronics and combat system. So it would have been obvious that what we could procure was the combat system. We have been dealing with that kind of system for a long time. We have provided the French government and other government with that kind of system. So it's our part of the job. We are not as good with ships, and it would not have made sense for us to take the responsibility of the ship, which would have been manufactured by someone else. So it became, I think, rather quickly evident that it would be easier for us to bring an offer where through a consortium. Which we would have all the military equipment, and the other would have the ships.
There is a suggestion that there was a possibility or opportunity to pad the pricing when Thales had to prepare its quotations. Now, in paragraph 31, which appears on pages 8 and 9 of your statement, you are actually addressing that perception or allegation. Can you please deal with it?
So I think that I understood, and bear in mind I was not there at the time of the negotiation, but that negotiation process was pretty transparent. That means that, of course, the South African authority wanted to have the best equipment for the cheapest price, and so there were a lot of discussion, and of course during those discussions there were variation in price, and the way you have variation in price usually in that kind of large contract is that you are looking at what risk and responsibility you are taking on the technical side, because if you have a complete control of the system you are delivering, meaning that it's something you have already done, and you have you know what your supplier are going to do. You have a way to reduce the price. Otherwise, if you don't, if you look at other companies that you have never worked with, you are taking a risk. And if you are taking a risk, that means that you are going to take build into your price contingency to allow some margin for the risk that you are taking, and it's specifically true in that kind of system where you have to make sure that it's a very complex system from what I understand. I'm not an engineer, but I understand it's very difficult, that all those, you have different components on those systems, and at some point they have to talk to each other and work together to provide the service they are supposed to provide. So that means that if there is something which doesn't work, the whole system will not work.
Now, there is criticism to the fact that which is stated as a fact, that your company presented a quotation at a certain price, but it later then marked down the price. And the suggestion is that this was improper, and it must be tainted with an element of corruption. Can you explain that, in particular focusing on paragraph 32 of your statement?
Yeah. So I think, as I said, during the negotiation, there are a lot of things which are changing. But first of all, I've never heard that a price would be reduced by way of corruption. Usually it's the opposite. But anyway, I think that what allowed the price to be reduced is that the amount of risk has been reduced. And for example, I know that there was various possibilities to various components to integrate, and of course, if part of those components were coming from Thales Group, other company of the Thales Group, that would reduce your price because, of course, Thales has an understanding how its own product works, and knows that he could provide a company, for example, like IDS, who is in South Africa, could help if at any time it's necessary, or even if that company knows already has experience in such system. Here we are talking about a very complex system. So when you choose your own product, you minimize the risk, and if you minimize the risk, that means that you minimize the price. You reduce the price substantially.
Would you see bearing in mind the experience that this company had in arms acquisition, would you see the reduction of price as being something out of the ordinary, or is it something that one can see does happen from time to time in transactions of that nature?
I've never seen a discussion where you don't have to reduce the price. It's always, of course, a lot of pressure from government to have the price reduced because they are bound by their budget, and if they don't abide by their budget, they would be in trouble. So that's and they not always tell the contractor what is their real budget, but they will always tell you, please reduce your price. I have heard that from customer everywhere in the world.
Right, thank you. Now, in paragraph 33, 34, 35, and 35 of your statement, you're just dealing with the logistics that you would follow the acquisition process, that is conclusion of the agreement, delivery, conclusion of the agreement as well as delivery. Now, it is correct that in the agreements that were concluded, there were also provisions for the offset obligations. Is it correct?
Yes, this is correct.
And in paragraph 36, 37, and 38, you are alluding to this fact, and also you have attached a document marked GC1, which appears on page 13 of your statement. Do you see that document?
Yes, I do.
Will you please inform the Commission as to what the purpose of this letter was?
This is a letter from the Department of Trade and Industry which confirmed that Thales is informing the Arms Corps that Thales has performed its obligation arising from the supply, an IP obligation arising from the supply of the covered combat ships.
Right. I noticed that this letter is dated the 15th day of May 2009. At that time, were you already in the office that would ordinarily receive this type of communication or not?
I'm sorry, I didn't understand.
Reading from your statement, you indicate that the position that you are currently occupying, you occupied in 2003, and you have been continuously engaged in that position.
Yes.
Now, bearing that in mind, are you able to say as to whether this letter from the DTI, page 13, was received by your office, or is it a document that came to you through just ordinary corporate practice?
This document came to me through we do have a subsidiary which business is to deal with offset, because offset obligation is something that we are familiar with, that we have been taken in many countries. So that means that offset obligation were performed through that subsidiary, and the CEO of that subsidiary just gave me that letter.
Okay, thank you. Now I'd like to turn your attention to page 14 of the bundle. On that page, it's a letter dated the 23rd of June 2009, written by Armscor. Can you just record as to what this letter is?
So this letter is a letter from Armscor to TNF. I just have to mention, I think I state that in my affidavit as well, that TNF, which was previously Thales Naval France, is no longer part of the Thales Group. It's now part of DCNS, which is another French company, where Thales has owned 33% shares. So TNF is receiving that letter from Armscor, which confirms that it has successfully completed the TNF DIP and IEP commitment, which arose from the supply of the 4 frigate combatant suite to Armscor, and that guaranteed are now automatically expired.
Right. Now, just in summary, these letters serve to show that the Thales had discharged its responsibilities in relation to the DIPs and the NIPs. Now, are you able to give this commission information with regard to compliance and level of compliance? That is just to indicate as to whether there are instances where there was short performance and what was done in order to make up for that. And yeah.
Yes, I have a little bit more of detail. So the total amount of NIP commitment that Thales had was for 652 million US dollars. And we managed to our NIP investment to perform 191 million US dollar, and on NIP sales 461 million USD and 60% of export sales.
Maybe just sit. Let me just, Chairperson and Commissioner Musi, this information is not contained in the bundle that you have, because the challenges that the witness has or the company has relates to the disclosure of companies with which they actually participated in order to discharge the obligations. We are informed they need to get consent from the parties or the companies that participated. However, with regard to the figures that the witness is now giving, the arrangements will be made for those figures to be actually put on paper and delivered to the commission. If that suffices, I would then beg leave to allow the witness then to continue to give these figures to the commission. Should I proceed, Chair? Thank you. Then you may proceed.
Okay, just as a summary, I can say that we performed 110% of NIP obligations. That means that we exceeded the obligation that we had with sustainable business, and we do have excess credits. And we focused on small and medium enterprise. More than 80 companies benefited from Thales direct support or through EDC credit lines. That generated a consolidated annual turnover around $300 million USD, and which represents more than 65% of exports. And jobs, I think that we can say that we created or sustained more than 3,400 jobs directly, and indirectly around 6,800 jobs. So maybe I can give you some example of what company we.
Yes, please go ahead and give the examples.
For example, we acquired 20% equity in a company which is manufacturing solar panels. This company is having a turnover of 120 million US dollars and has 99% exports. It employed 219 persons. There is another company which is doing products silicon metal and silicon fume. Thales helped them with a loan to finance furnace upgrading, and turnover is 30 million USD and 90% to exports. And the employee, 337 persons. Another company which is doing with medical waste. So we upfront a grant to that company. And help them to continue their business.
Yeah. Just before you proceed further, you mentioned that there is this company where we did this and this and that, and you have already. It has already been indicated to the commissioners that the names of the companies could not be disclosed because of the fact that there has not been a consent obtained from the respective companies or the affected companies. With that in mind, would you be able to produce documentary evidence for the attention of the commissioners so that they can be able to discharge their mandate properly? And this may be a difficult question to answer on your own without getting instructions or advice from your legal advisor, but if you are able to respond immediately, please do so. If not, please indicate so that, yeah.
Yes, I think I will get the Commission the information that they needed to have a complete understanding of what we did as offset obligation.
Thank you then. Can we then proceed in the light of the undertaking by the witness? Thank you, Chair. Now, still on the offset arrangements, it is actually common knowledge to the Commission that in terms of the agreements generally, there would also be those 6 monthly review meetings that would be held in order to monitor progress and review ways of making sure that the responsibilities that the respective companies have discharged them and discharge them timelessly. Do you know as to whether your company participated in those meetings, and if it did, whether there was full attendance and participation or not?
From what I've been told, Thales participated in all those meetings, and I can show you some of the minutes of all those meetings, where you might see that there were about 18 meetings in total, and I gave you the 17th minutes of meeting. The 19 was only a draft because we moved the office by the end of the year, and it seemed that the last signed minute of meeting appeared to have been lost, but the previous one is there for you to look at. So I understand that we attended all those meetings.
Right, thank you. Now, when you were dealing with your statement right at the beginning, in particular, in paragraph 5, when you were dealing with paragraph 5, amongst others, you stated that from 2003, you got involved in the investigations in South Africa, the investigations pertaining to the arms procurement.
Yes, I did.
Now, can you please indicate to the Commission as to how you participated, as to whether there were any meetings that were held, if so, with whom they were held, and what happened, one at a time?
I think there has been a lot of meeting, and I cannot pretend I attended every meeting, but the first meeting I personally attended with South African authorities was in September 2003, which I understand was a follow-on on a previous meeting which took place during the summer of 2003 with the director of the National Prosecution Authority in South Africa, Mr. Bulelani Kuka. So I was not at the first meeting, but I was at the second meeting where Mr. Bulelani Kuka wanted to meet with Mr. Tetar, who has been accused of many things in South Africa.
Now, this meeting that you are talking about, that you said was held in September between Mr. Nguka and yourself and the other, is it the CEO?
No, it was Mr. Teta, who had been CEO of one of the Thales company in South Africa.
Yes, where was that meeting held?
That meeting was held in Paris at his hotel.
And what? Just give us briefly the purpose of the meeting and the outcome of that meeting.
The purpose of that meeting was that the prosecution wanted to get Thales cooperation in the current investigation in South Africa, and during the first meeting I did not attend, but which I was informed by Mr. Perrier, and who was the attendee from Thales. I understood that Mr. Perrier had agreed that Thales would cooperate with the investigation, and the request from Mr. Nguka was to meet with Mr. Tetar.
Yes, and what was addressed at this meeting?
So at the meeting, Mr. Nguka wanted to have confirmation of certain facts which allegedly occurred in South Africa in 1999 or 2000. I don't recall exactly the dates, and so he wanted to interview Mr. Tetar about what happened in those meetings, and Mr. Tetar is not someone very easy to deal with, and I don't know exactly what happened in the impression they got to each other, but Mr. Tetar got very angry very soon, and Mr. Nguka as well. So the meeting didn't last that long, because it appears very quickly that first of all Mr. Tetar would not want to go to South Africa because he had heard about a warrant of arrest against him, so he would not go to South Africa, and he was not satisfied with the answer he received from Mr. Nguka. So I think the meeting didn't last more, 3/4 of an hour maximum, really maximum.
Is there any agreement that was reached, or how was the meeting closed then?
The meeting was closed that Mr. Nguka said that he was not happy, Mr. Tetar said he was not happy, so there was no conclusion, nothing came out of that meeting.
Are there any documents that were drawn out of that meeting, or there was nothing that was drawn out of that?
No, nothing was drawn out.
Now, other than that meeting, relating to the investigation in South Africa, is there any other meeting that you attended?
Yes. I attended at another meeting in April 2004 at the residence of the Ministry of Justice, Mr. Maduna. I think it was beginning of April 2004.
Around April 2004?
Yes, it was beginning of April 2004.
Now, can you tell the Commission as to who attended that meeting, how this meeting was arranged?
I don't know exactly how that meeting was arranged, but it seems that for some time there has been some understanding that there would be a meeting. I think that we had some lawyers involved, and through that channel the meeting was arranged. So I traveled specifically from France to attend the meeting. The idea was we want to exchange our view as to what kind of cooperation we could and what kind of agreement we could get. Thales could get, and South African authority could get. So the meeting was at the residence of Mr. Maduna, because I think he has been in an accident, so he was not at his office. When we came in, we just say hello to someone who was leaving the house. I don't remember her name. I was told later it was a special advisor to the president, but I could not tell you.
A special advisor to the president, which president?
South African. I'm not sure.
South African president. I could not confirm really exactly who she was, but I think that she was someone important. So I was there with Mr. Moineau, who at the time was the CEO of the local company here in South Africa, Thales Tint Pty. And I was with my attorney, Mr. Dryman, as well as Mr. Kesi Naidu and Mr. Suklal.
So you say when you arrived... Okay.
Mr. Nguka was present.
When you arrived at the minister's residence, you see this person, the special advisor, or whom you later came to know as the special advisor of the president, was leaving the residence of the minister.
Yes.
And whom did you find at the minister's home?
At the minister's home there was Mr. Nguka, and I don't remember if there was anyone else when we went to his home office, I would say.
And what was the purpose of this meeting of April 2004 at Minister Maduna's place?
So at the time, Tint Pty was charged with, together with Mr. Shabir Sheikh and other companies, with, I think that was corruption. And we wanted to get the whistle of the charge against that company, as well as a commitment that we would not be, no officer of the company would be prosecuted.
And how did this meeting go?
We understood from Mr. Nguka said that he would be ready to drop the charge because he was not looking for prosecuting Tint, but he wanted to have some confirmation that Mr. Teta was the author of the so-called encrypted fax.
Right. I note that you describe it as a so-called encrypted fax. And then did you manage to reach an agreement, or what is the position?
Yes, we agreed that it was we would go back to and speak with Alain Teta, who was at that time working in France, and try to get him to confirm that he was the author of that so-called encrypted fax.
Now, this document, that you describe as the so-called encrypted fax, did you manage to see that document at the residence of Mr. Maduna, or ultimately?
So we said that we would agree to talk to Mr. Teta, but before we could talk to him, it would be necessary to see that document, because so far the only thing that we had seen was a printed document in English, and so we wanted to have the actual document and make sure that it existed first and what it was. So it was arranged with Mr. Guka that we would go the day after and visit Mr. McCarthy. I think it was Leonard McCarthy at his office, and he would show us the encrypted facts, so-called encrypted facts. So the day after, we went and visit Mr. McCarthy, and I was with my attorney, and we were shown that document. And it was under a plastic envelope, and I recognized Mr. Tetar's handwriting because I knew Mr. Tetar handwriting for former dealings with Mr. Tetar.
And how did this document look?
So it looked as it had been crumpled. So it was one piece of paper, A4 piece of paper. It was handwritten. There were a lot of scripts and scribbles around it. So it was in French, of course. And it was clear that it had been crumbled, but someone has taken care of putting it a little bit better than it was probably at the beginning. And so it was not really understandable, I would think.
I'd like to draw your attention to page 58 of the bundle. Now, that document that you see in page 58 is a copy. We have not had opportunity to see the original, but are you able to say whether you do recognize this document or not?
Yes, I recognize that document. The only difference is that the copy, I think that the original was written in blue, so you cannot see the blue here. And it was only one page, that means that it was written on the face and recto and verso.
So you say the document that you saw that looks like this one was actually written on the page and overleaf. It was not two separate pages.
Yes, exactly.
Right. Now, in your introduction, you indicated that you are French and you live in France. And this document, we are told it's written in French. Do you confirm that it is what appears here is actually French?
Yes, it's written in French.
Now, there have been interpretations of this document that have been placed in public by the media and other sources. Turning to page 60 of the same bundle, there is a typed document which also appears to be written in French. As you say, what we see in page 58 and 59 is French.
Yes, I saw that, and it's typed in French.
In page 61, you see a document that at the bottom, it's written, translated from a fax copy by whomsoever, but clearly this is seems to be a translation.
Yes, I see that, but I'm not sure that it's a correct mention that it's a translation from a fax copy.
Now, yeah, you say you're not sure whether it's a translation to a fax copy.
No, what I mean is that, in my view, the handwritten note, memo, or letter, or whatever, is not a fax. It's just an handwritten note.
Right. In the original that you say you saw, which was written in blue and put in a transparent plastic bag, the one that you say it looked crumpled. When you looked at that document then, was there any indication on the document that it was a faxed document?
No, in my view, it was clear it was not something which could be sent through a fax machine and received by the recipient.
Now, turning to the contents of this document, which is on page 58, well, now it becomes difficult because you say that the translation, this translation that you see in 61 refers to a fax document, and you don't see this one as a page 58 as a fax document. With that in mind, I will nevertheless ask you the question that I want to ask you. And I will tell you why, or the Commission, why I'm asking this question. It is because, Chairperson, before the Commission, there is a statement that is now also placed on the website about the encrypted fax and about the interpretation of that document that is described as the encrypted fax, and also in that is in the statement of Dr. Young, and even in the evidence that was presented by Dr. Young, there was also the introduction of the encrypted fax. While it is so that the commissioners did get in and make a ruling about talking further with the maybe merits of that, the fact of the matter is that in the statement there is a full interpretation by the author of the statement, which is in the public domain, and for that reason we would like to proceed then to lead this evidence. Thank you. Thank you, Chair. Now, the page 58, assuming that page 61 is the interpretation of page 58, is the English interpretation of page 58, would you concur? Maybe before I ask that question, you have alluded to the fact that you are French. You are presenting your evidence in English. You have written your statement in English. And thus far, you have illustrated an understanding of English. Now, are you in the position to can assist this commission with the interpretation of this document that appears on page 58?
Yes, even if my English is not as good as it should, I can say that I can. It's a rather simple document, so I can help the Commission with the translation.
Right, thank you. Now then we can go ahead to what I had initially wanted you to do, to firstly remark as to whether this is whether what appears on page 61 is a fair and accurate reflection of what appears on page 58.
Not completely. I think it's it's not a bad translation, but there are some words I would not have translated in the same way, and it's not something that basically it's not it's most. It's accurate in most of the parts, but there are some parts I would have translated differently.
And can you highlight to the Commission as to what it is that you see as an inaccurate translation of this document that appears on page 58? You can.
Yeah, it would be easier. It would be easier. Okay. Yeah. 58 and 59. So, for example, on the third line, I think that there is a translation, the translated document said during a private interview. I don't think that I would have called that a private interview. The word interview is not really accurate. It's just a private meeting, I would think, that you would say. It's, of course, interpretation is different people, but interview seems to be, there were question and answers and things like that.
Okay, thank you. But would you say that the word private does appear on the French version, or appearing on page?
Yes, but I think that it means that in French it means that it was not a public meeting.
Okay, thank you. Then you can go ahead about other inaccuracies, if any.
I'm not sure that I would have translated the word which are on the second paragraph, third line, in an uncoded form, because what is in French is a little bit different. It's not encoded, but more or less codifié means there is a formal word. It's difficult to explain, but encoded for me in English doesn't have the same meaning that codifié in French. I don't know what would be the best word for that translation, but I don't think that encoded is the right one.
And any other?
Yes, I think that, yeah, it is inaccurate, and mostly because it appears that at the time this document was supposedly written, there was no investigation. So I think I would have translated the word enquête as inquiries more than investigations. It's on the bullet point, first bullet point, first phrase of the bullet point.
Right, and anything else?
From the top of my head, I cannot tell you, but I know that Mr. Teta, who wrote that, had some take exception to that translation.
You say the author of the document takes exception to the translation.
Yes.
Now, his objection to the interpretation of the document, was it, as far as you know, was it ever communicated to the South African authorities?
Yes, it was. Mr. Teta filed another affidavit where he gave his exception as well as his explanation of the circumstance of this document.
Now, there are three documents in this bundle which are described as the affidavits of Mr. Teta. And I would like to take you to the affidavits. Before you deal with the contents, the affidavits are lengthy. One is very short, the second one is slightly longer, and the other one is even longer. I will not invite you to burden the record by reading into record the full contents of the affidavits. What I would like to do, the affidavits appear on pages 60, it's three affidavits. The first one appears on page 65, yes, 65 of the bundle. The second one, 66 to 70, and the final one, 71 to 87, to 88 commissioners. Now, will you please just advise the commissioners about the essence of the affidavit that appears on page 65? May I mention that that document is written in English and it's just a one-page document. What is the essence of this affidavit?
This affidavit is what was requested from Mr. Teta after the meeting with Mr. Nguka at Mr. Maduna's office, and it was just a confirmation by Mr. Teta that he had written the document. It's handwriting.
In his own writing. Now, in return for writing that affidavit, is there anything that was supposed to be traded off or not?
Yes, in providing this affidavit to the NPA, Thales Tint would be withdrawn, charge against Tint would be withdrawn at the SABC trial.
Thank you. Now, I'd like to take you to the second affidavit. Just before we leave that affidavit, may I just place it on record that the affidavit that we were dealing with, it's dated the 20th day of April 2004. Now, the next one is dated the 12th day of May 2004. You'll notice on page 69 there's the 10th day of May, and then the notary's date stamp is the 12th, and we shall thus go by that date. This document, what is the essence of this affidavit? And if necessary, please just outline as to circumstances that led to the second affidavit being drawn.
So I think this second affidavit resulted from discussion between the prosecution authority and Mr. Naidu, where they were satisfied with the first affidavit, but in some way they wanted to have more than just the authorship of the document. They wanted to have an understanding of what it meant. So we went back to France and talked to Mr. Tétart and tried to see what he could tell us about that famous document. What was the document and what he intended to say in that document. Because, as I said, it was not that clear what he was, the meaning of the document. So, Mr. Tétart made that affidavit where he explained what was the circumstance of this document that he recognized having written, but never sent and just put on the waste paper bin. So he explained that in the meeting, there was never a meeting where a bribe was ever discussed with Mr. Sheikh or Mr. Zuma. He just recorded a conversation that he had constantly with Mr. Sheikh. That Mr. Sheikh was just always asking for additional money, playing a bigger role than he had in with Thales. That he knew very important people.
Okay, I'd like to come in here, maybe just to focus your attention to what I've already said. We'll not be dealing with the entire contents of the affidavit, but the essence. Now, in paragraph 4 of this affidavit at page 66, in line with your evidence, the deponent states that he wishes to state that he does not agree with the interpretation recorded to Annexure C by the state, and the basis is that the state seeks to draw inferences from Annexures X which are not justified. And then he goes on to table the contents of the interpretation, and then in paragraph 6 he then responds to the aforesaid interpretation. Do you see that paragraph 6 is in page 67?
Yes, I see that.
67 to 68 document. Do you see that?
Yes, I see that.
Now, can you just summarize to the Commission as to what his responses are to the allegations?
So, yeah, he says that he never, Mr. Sheikh never requests from him or Thales the payment of a bribe for Mr. Zuma. That at no time during that meeting he had with Mr. Zuma and Mr. Sheikh there was a discussion of a bribe, and the document, the so-called encrypted fast has never been minutes of meetings, a record of minutes of meetings, and he had that he never instructed that document to be sent or faxed to anyone or typed.
Right, thank you. Then I'd like to take you to the final affidavit, being the last one that we have in our possession from Mr. Tétart. Now, what was the purpose of this affidavit, which appears on pages 71 to 89?
Yes, the purpose of that affidavit was to try to obtain the lift of the warrant of arrest against Mr. Tetar. In I think it was 2009 or something. It's probably yes. It was signed in March 2009.
Yes, and it is correct that in terms of this affidavit, Mr. Tetat goes to deal with the conduct of the National Prosecuting Authority in relation to him as regards the toing and froing of issuance and withdrawals of the warrants of arrest that were issued and then later withdrawn and so forth. That the commissioners can read, but is that actually even the essence that is captured in this affidavit?
Yes, Mr. Teta said that he has been treated badly all over the years by the prosecuting authorities, and he wanted to say that he has been he was accused of things that he never did, and he was in some ways assaulted by the prosecuting authority.
Right, just finalizing on these affidavits. Unfortunately, I have to do this to you. Take you back to page 68. This has just been brought to my attention by my teammates here. In particular, paragraph 5. I think it's a subparagraph 6.5, Roman 5. Do you see that?
So that.
Now, in that paragraph, there is an explanation relating to the amounts of 500,000 rand. The explanation by the author of that document that is said to be the encrypted facts.
So Mr. Teta explained that this 500,000 rand was not related to the payment of any bribe to anyone, and it just said that it was a request for fund by Mr. Sheikh.
Now, in your evidence, I think it's at paragraph 11, as you were talking about the business of Thales, amongst others, you spoke about its business being to deal with the encrypted connections and so forth. Are you able to enlighten us about the encryption, as to when you talk about an encrypted fax, what you mean, and how can what is the process leading to actually producing an encrypted fax?
Yes, I think that the characterization of encrypted fax is completely wrong, in the way that encrypted fax are only going through a fax machine which is encrypted. So I'm not a technician, and I will not go into the detail, but in fact there is a kind of machine which has protection against hacking from third parties. So it means that you have a fax machine which looks like any other fax machine, where you put your fax on, and the only thing it's sending the document you are sending through a line of communication which is encrypted. That means that there would be an algorithm which would prevent third parties to that communication, to enter into the communication. Of course, you have to have another encrypted fax machine at the other hand of the communication. That means that if you want to make sure that no competitor would have access to the document that you are sending through that line of communication, the normal network, it would be not be readable by anyone but the recipient. But it's not the document itself which is crypted, it's the communication line which is crypted by an algorithm.
Now, we're just trying to understand the encrypted fax. Is it possible to regenerate and produce the data of the information that has been sent by that type of fax?
No. What is possible to do is to check into the fax machine itself is the sending of the document. That means that you will have the number of the phone number or fax number of the recipient, as well as the time it has been sent and number of pages which has been sent.
But not the data.
Not the content of the document.
Now, you stated while you were presenting your evidence that you would be involved in investigations that were conducted by your company in respect of any impropriety. Now, are you able to tell this commission as to whether the document that is described as the encrypted fax, as to whether there is any indication that that document ever reached any of your offices, be it in Mauritius, be it in France, or anywhere else?
No, we checked when the alleged encrypted fax on the other side to make sure to see whether a document was received from South Africa on that particular day or time, because as you know the document is not dated. So we try to reconstruct the number of fax which has been received in France. Same thing in Mauritius, and there was no record of any document coming from South Africa during that period of time.
Now, when you were with, is it Advocate McCarthy or at the NPA, when they showed you the document that they showed you, did they show you anything that shows that the document had in fact been faxed from one point to the other?
No, they never showed me anything which would really record the sending of the document.
Is there anything that you want to say in this respect? Because I now want to turn further on to deal with the criticism that there is about.
No, I'm fine.
Right. In your last portion of your statement, I think you are dealing with issues pertaining to allegations. Now, broadly, the criticism that Thales seems to have attracted from Paul Holden, Feinstein, Dr. Young, and other critics that have added their voice to the criticism of respective suppliers. Broadly, that is divided into three topics. That is the acquisition of the shareholding in ADS, the unlawful competition, as well as corruption broadly. They have indicated as to why the basis of corruption and so forth. Now, you are generally also conversant with the criticism that has been leveled, which is out there in the open, be it through the record of the commission or the books that have been written and so forth, and even the submissions of Paul Holden and Feinstein have been brought to your attention with specific reference to what entails Thales. Now, can we first then go ahead to deal with the acquisition of holding in ADS? What is your response to the criticism? Because the criticism is that, I mean, how could you do this? How could you engage with them? And that smacks of some improper conduct in that it seems to have been created in order to get access to what had already been set aside for ADS.
I really think it doesn't make any sense. It has been Thales' strategy since the privatization of the company is to appear local in every country where it's doing business, meaning that we want to the country where we operate to consider that Thales is a domestic company, not an international company who is going to do a deal and then goes elsewhere. We want to have a footprint in countries. So how could we achieve that is by buying out companies who have a local standing and local experience with the main customers. So we acquired companies like in this way. For example, in the UK, we acquired the company called Racal in 2000. We acquired companies in US. For example, we have a joint venture with Raytheon in the US. We do have a joint venture in Korea with Samsung. We do have a lot of companies like that. So acquiring a company like IDS would make perfect sense and would really be in line with the strategy as decided by the chairman.
So, in actual fact, what you are alluding to is that this your acquisition was not something out of the ordinary. It's actually the strategy that had been adopted by the country for the purpose of commercial transactions, even with other countries.
Exactly.
Still, bearing in mind that this is a strategy that had been adopted by the country, and taking your position into consideration as being illegal for this a company in particular, is there anything that has come to your attention that seem or that suggest or that would cause you to suspect that this acquisition of shareholding was visited by some impropriety from the part of Thales?
No, I never heard that anything improper was ever occurred in the acquisition of IDS.
Now, the next topic that I would like to invite you to deal with, part of the allegations or criticism, relates to the unlawful competition. And this manifests itself in the form of the evidence that has been presented by, amongst others, Dr. Young, and the allegations that are found in the submissions that have been presented to the commission by the witnesses that have reservations about the acquisition process itself. Now, the unlawful competition, it is said that, like for instance, some were allowed to to submit their bids out of time, and yeah, there was some, manipulation, as Dr. Young states it in his statement, page 100, paragraph 408, that there was actually even some manipulation. One is mindful of the fact that the evaluation would have been done by the Department of Defense, perhaps assisted by AMSCO.
No, Thales didn't have any way to handle the competition process, and nor did it have any confidential information would have been improper. I think that there has been a litigation by some competitor who was unhappy with the outcome of the competition, and this litigation has been settled without Thales being asked to contribute to the settlement agreement. So.
Now let us proceed to deal with, just before then, may I just take a moment and check the notes, Chair? Page. Thank you. Yeah. May I proceed? Thank you. Page 43 of the paginated bundle. Paragraphs 420 and 421. It's about that issue relating to the Taiwanese. While it has nothing to do with what we are dealing with, but for the purpose of the credibility of the players in the acquisition, it would help if you are able to enlighten the Commission about this, just to say as to, without getting into the merits. The Commission is not interested in that because it will not.
Yes, I'm not going to go into the detail with the dispute with Taiwan, but anyway, what I must say, it's the only thing is that it was a commercial dispute for breach of contract, which went to arbitration between Thales and the Taiwanese authorities. And with respect to criminal charge, there has never been any criminal charge against Thales or any of its officers and employees. And in fact, the reality is that Thales filed a criminal complaint against certain individuals. And that was the start of the story. So Thales was the victim, not the offender. And there was any charge were dismissed against Thales. There has never been criminal prosecution on this matter.
Okay. Thank you. So what you are saying is that actually this was initiated by a criminal complaint by Thales against the Taiwanese company. Okay. Then, shall we then proceed to the next heading? That is corruption. Now, the basis of claiming that there was corruption generally, amongst others, there is a mention of the meetings between Thales and their high-ranking persons, such as the politicians, cabinet ministers, and so forth. What is your response there to?
I have never heard anyone telling me that there has been corruption in this matter. Of course, when you are dealing with procurement contract of such magnitude, dealing with military, there are meetings with officials, government officials, as well as high-ranking official of the company. You know, it's not usual business for a government to acquire companies, so they want to meet the CEOs, managing director, to make sure that they could trust them. So it's really a normal way to deal with that kind of military business, that you will meet with government official, high-ranking officers of the Navy or the procurement agency. It's just something which is our day-to-day life in that business.
Right. According to your knowledge, are there ways, or rather, according to your knowledge, would you say whether Thales would actively participate in encouraging impropriety in order to conclude or to procure good or big business transactions?
No, because we had put in place a compliance program to make sure that there is no impropriety regarding the procurement business, and of course it's illegal, and we don't want to be involved in unlawful activities. And as you know, we are doing business all over the world. We cannot be at risk by people facing a charge against the company itself. So we have put a lot of efforts to make sure that there are proper treatment of any dealings, to making sure that every employee knows that there would not be acceptable behavior than to enter into unlawful activities. And so it's something that it's very important, and something which the chairman address regularly to the employees as well as to other stakeholders, to make sure that we have a standard of ethics which is renowned in the business we are dealing with.
Now, according to your knowledge, is there any person that has been charged and or convicted for matters arising from the arms acquisition of South Africa, which was commenced in 1998, or not?
No, no one has ever been charged with that particular procurement contract.
Right. In conclusion, is there anything that you'd like to say to the Commission that you believe might have been left out in your statement and can still be of assistance to the Commission?
No, I thank the Commission for listening to me. I'm sure that my French accent is not always easy to understand, so thank you for your time.
Just one more thing. One of the considerations that should be made by the Commission is the cancellation, a recommendation for the cancellation of these contracts that were concluded in 1999, and in your case, your contract came into effect or operation from April 2000. Is there any comment that you'd like to make about that, as to whether that could be practical? What are the consequences that could flow from that?
First of all, I think that we met all the obligation we had under that contract, and we delivered combat suites which are state of the art, and the country should be proud of it. And I think that the consequence of such a cancellation would be really never heard of. And I don't know if that means that we'll have to rebuy the ships. I don't know what we will do with that. But it's not something that I really consider as something feasible.
Right. Commissioner Musi, as I have indicated during the presentation of my evidence, there is a substantial amount of information that will be found in the documents that are attached. However, we have made sure that the essence of the information is carried through the public hearings. Otherwise, we would not finish today. Thank you. That concludes the evidence of Thales.
Besides Dr. Young, is there any other person who wants to cross-examine the witness? Thank you. Dr. Young, do you have any intentions of...
Can you just not do that side?
Do you have any intentions of cross-examining the witness?
Yes, I do. First of all, I'd like to move where there is a loud microphone, also allow me to read my laptop computer, and this will be correct. There are, I think, just two documents that I'd like the witness to refer to, and they are the evidence bundles. I've got the relevant index numbers, and I can just make sure that they are available for you to make those copies for them.
More or less, how long do you think your cross-examination will take?
Probably about an hour.
Okay. Let's adjourn. Maybe let's adjourn for 15 minutes in order to allow you to do what you need to do. Then we'll then continue that cross-examination. We'll adjourn.
I sit here? Yeah, no, that's all right. Is that one working? No, but you just take this paper. Okay, so I'm walking backwards and forwards. No, but you mustn't. I don't want to trip over it. Yeah, okay, there you go. Much rather than I'm walking backwards and but yes, when we started, there was no sound. Then the chairperson looked at me. No problem, please. Yeah, it's got a radio. The radio doesn't work anymore. It's cellular radio. But this is a decent. Yeah, makes calls. Look at my phone. So it's old phone, so it's like a brick. You are listening to your off. I don't my phone, I go look for something. Because you can't see it in the sun. Reflects. You talk about the light in here. How do you see when you're staying in the fog? Yeah. No trees, you can't see.
sama nie goed papier.
Che cara no la be ba to ka dira ban ji ba ba
Dr. Young?
Thank you, Commissioner. I probably have to state at the outset that I haven't done this before, and I've only been a witness, so I'm going to just do this to the best of my ability. Madam Gurria, I hope I've got the pronunciation reasonable. May I refer you to paragraphs 40 and specifically 41 of your witness statement?
Yes.
Well, paragraph 40 is the introduction of it, and I won't, in the interest of moving forward as quickly as possible. But specifically with regard to paragraph 41, you say here that most of these allegations fall outside of the scope of the terms of reference of the Arms Procurement Commission, require no response in this statement. May I ask you, of course, this is with specific reference to my own evidence, of which I think you are mostly aware. Which of the allegations regarding those referred to in paragraph 40, to which I have referred in my evidence, fall outside of the scope of these of this commission?
Mr. Commissioner, one wants to be light in objecting. Dr. Young has indicated that he hasn't experience in this and he's not a lawyer. But I think this pushes it too far for a witness without pointing to specific instances. I might also say that with those instances to be put, one might be tempted to object a second time simply because they do fall outside of the scope.
I think I agree, because, Dr. Young, you can't assume that the witness knows exactly what you said or the entire allegations that you have made to him. Probably you need to be more specific.
Okay, I'll have to do that as I come to those individual points. Okay, turning to page 6 of your witness statement, paragraph 23. This is quite a long paragraph, but I presume your statement there that there was virtually no other global competitor that could match it. Clearly, you referred to Thomson CSF or Thales that could not match the combat suite provided by Thomson. Is that correct?
It's not clear. Could you repeat your question? Because
okay. What you've said here, about 5 lines from the bottom of your paragraph 23, that virtually no other global competitor could match it. Is it correct to say that no other global competitor could match the combat system that Thomson or Thales was offering at that stage?
Mr. Chair, if I may, I think that the question actually isn't related to what was stated. I really don't want to make Dr. Young's position difficult. I do understand the predicament, but that would not be fair to ask the question in that way.
Dr. Young, which point are you trying to make there? Maybe if I understand it, I can try and explain it to the witness.
Yes, maybe that will be a type of inquisitorial cross-examination. She's made a statement, it's her own statement, that virtually no other global competitor could match it. I'd just like to know what does that mean?
I'm sure the witness understood. Virtually no other competitor can match Thales as far as combat suites are concerned. What did you mean by that?
What I mean is that because of the ability of ADS combined with other Thales companies, that we had a very competitive advantage compared to other competitors with that kind of system.
And if other global defense companies offering combat suites had also teamed with ADS, would that have been a viable competitor?
Dr. Young, we are going to speculate now. If other global companies had combined with ADS, which ones are we talking about? Should we leave the witness to speculate? Shouldn't you try and be specific so that the witness can understand and be in a position to answer the question?
Okay, well, certainly in the context of this whole acquisition, it was well known that various other companies were also wooing ADS, and here the witness has said that it was the combination of Thales and ADS that made this a competitor that could not be matched. So anyway, be that as it may, if I may just ask the question, if other European naval combat system suppliers had been able to make offer, would their offers not have been competitive compared to the Thomson ADS offer?
It's a bit of speculation, but anyway, I think that there were other competitors, and the only thing that I said is that we had a competitive advantage having ADS within the Thales group.
I don't think your witness statement says that specifically regarding ADS. I think that it has to be that there could have been many other, well, a substantial number of other viable competitors. It could not possibly only have been Thales.
I don't really understand the question, but if you want me to say that there are competitors to Thales, of course there are competitors to Thales for that kind of system.
Yes, and if there were proper competitors, they would also have been able to put in a competitive bid, which could at least match, in your own words, the competitive bid put in by Thales and ADS.
I think there were other competitors, and they had competitive bids, and that's normal. International competition.
Of the documents from the evidence bundles, and they are in front of us, hopefully. That's RMY 67 and RMY 70. I just wanted to get a clarification on RMY 70 first. My question is, okay, this is clearly a Thomson CSF international document. Can you identify, first of all, who the author and the recipients are, as well as the date?
Yes, I must admit I've already seen that document, but years ago, so I'm not familiar with it today. So the author was Mr. de Bollardière, and he sent that to Mr. Bussière, which Mr. de Bollardière being someone from Thales International, or Thomson CSF International, as it was known at the time. And Mr. Bussière was, I don't know his title, at NCS, it means Thales Thomson CSF Naval Combat System, which is another subsidiary of the Thales Group. And he copied on that communication Mr. Tetar, who was in South Africa, and he copied as well as his boss, Mr. Denis, who was also with Thales Thomson CSF International.
Okay. Clearly, I don't think you addressed the date. Maybe I wasn't concentrating, but it's the 9th of July, 1998. And my understanding, and I'd ask you to confirm whether this is correct, that both Mr. de Bollardière and Mr. Denis are both, what at least in South African terms, are directors of Thales International. Is that correct?
No, that's not correct. They are not directors. They are, in the sense that they are not corporate directors. They are just employees of Thales International. They might have some title, but they are not directors.
Okay, but they are very senior employees. Am I right?
Yeah, they are senior employees.
Okay, that's sufficient. There are a couple of questions leading from this. The first one is just for a matter of clarification, seeing that this is on Thomson communication. I just want to get to the right place. I'd just like you to turn to page 1362. So that's about the third page, I think it is, in that document. Okay, the fourth line down, the fourth point down, starts off the words decision taken previously. Would you read that out to us?
First, I should mention this seems to be a translation of some document in French, so I'm not sure if the translation is accurate, but if you want me to, I can read that translation. It says the decision taken previously that ADS be the nominated combat suit supplier has been cancelled, and as a result, the local system combat suit supplier has not been nominated.
Okay, so if you're representing Thomson CSF here, which I think from what I understood from your first part of your witness statement, would you confirm that that is a correct position that Thomson came to understand at this particular point in time.
Mr. Chair, I must object. I think we're asking the witness, who's neither the author nor recipient of the letter, to confirm its contents, where she's already said she's not sure that the English translation accords with the French. I think it would be pushing it a little bit too far to ask her to make that confirmation.
Dr. Young, I think the objection is valid.
Okay, then I'll have to deal it with this way. Okay, first of all, I heard Attorney Ramagaga communicating, engaging with the witness regarding English, and I think her English is certainly sufficient for these purposes. But I did refer at least to the page 1359, and that was the one where I asked the witness to identify the author and the recipients of that, and that is the original the original document. So if I could ask her, as she's clearly fluent in French at least, and her English is much better than my French, whether she could go to the equivalent paragraph on that, this is just a 2-page document. So on page 1360, also four dashes down, four down, there's the equivalent of that in French, and confirm whether the French and the English versions mean the same thing.
Mr. Chair, just thinking it through, that's an entirely justified question to ask, but where is it going to? Because, again, all that the witness can then say is that the English is a correct or an incorrect translation. She can take it no further. It's not something that's going to aid the Commission, and it will unduly delay it pursuing this line unless there's another point which escapes me.
Maybe let's give the witness a chance to respond to this one, and let's see where do we go from here.
So it seems to be an accurate translation.
It seems to be correct. So the English wording is a fair representation of, and that was, I'm asking a question, that was the position known to Thompson at that time. Is that a fair summary of that point?
At least it seems, via what I am reading from this document, that it's something that Mr. Sheikh said at the meeting.
Yes, that's correct. Now, are you aware that Mr. Sheikh had a conflict of interest as regards also the business interests of Thompson CSF?
I'm not aware of that.
Okay, would you accept it if I said that, slightly later than this date, it was a conflict of interest that was formally declared, but by this stage he was Chief of Acquisitions, and that, the reason for his conflict of interest involved the fact that his brother, Shabir Sheikh, who I'm sure you recognize his name, was actually a director of a Thompson subsidiary in South Africa.
Before you come in, Dr. Young, I'm not sure where that point is taking us to. She says she doesn't know. Let's get to the next point.
Okay. This letter also refers. I do have a reason for these questions.
Dr. Young, you might be having reason for this question, but the witness says, I don't know. So that's why I'm saying to you, let's get to the next point.
With respect, as far as I was aware, that she is representing Thompson here in all respects. There's no, all the other people have retired or left the company, and as far as she's representing the company here. So there's somebody has to be able to represent the entity in respect of these commissions.
Can we get to the next question, Dr. Young?
Okay, if we may, and certainly if you want to challenge the English translation, I'm going to refer to the English version because I don't want to embarrass myself for trying to read especially read out aloud the English, the French words. The first point, number 1, on the first page of the English translation was 1361. Would you like to read that out to the Commission?
I can read, but I don't know where it goes. Mr. Sheikh was aware of our London talks and spoke about them without any restraint. More particularly, he has spontaneously mentioned the name of the tailleur to show us that he had a very good idea about our contacts here.
Yes. Now, I'm specifically asking these questions with regard to what you stated in your witness statement. Now, at some stage, I think it's your paragraph 32. Let me just find the record. Yes, paragraph 32 on your page 9. Would you like to find that?
I do have that.
Yes, the last three or four lines of that state that the commercial rationale and consequences of the transaction had been subjected to the most rigorous and transparent process and were subject to difficult negotiations. Now, the question is that, in your own words, this was subject to a transparent process. Could you explain the transparency of the process with reference to these talks held by your company, whom you represent, in London, as well as Mr. Sheikh with a conflict of interest, and with Mr. Talia, who refers to having a very good idea of your being your company, your context here. Could you explain how that falls into the realm of what, as you describe, a transparent process?
Mr. Chair, I think I understand what the question might be in due course. It might also be something that in due course, of course, I couldn't advise him. Dr. Young wants to make a representation. But as presently constituted, that's not a fair question. It's in fact several questions with value judgments built into them, which I think would be very difficult for the witness to answer.
Dr. Young, do you want to rephrase the question? And if you can, put these as short questions which it will be easier for the witness to understand.
Okay. The witness certainly came across to me, both in reading her witness statement and from what I heard of the oral evidence, that she has been involved in this process for many, many years. And makes a statement in her own words that this was a most transparent process. Okay, that's the first part, in her own words. If one takes the normal meaning of that very short sentence that she's just read out, I'm sure anybody would agree that those talks in London and references to people like an interlocutor with a nickname, the Talia, and contacts here are not part of the official acquisition process. Is that a fair question? Are those processes, are they part of the official process or not?
You know, I didn't attend that meeting in London, so I wouldn't know what was the subject matter of the meeting. The only thing I can read that memo, but I was not present at the meeting, and I don't know exactly what was discussed. What I was referring to in paragraph 32 of my witness statement is the way the negotiation proceed, and I think that the transparent process was always respected in a way that we explained the price. I've talked to people who were negotiating the contract, and they told me that it has been a very lengthy and painful process because every piece of equipment was discussed as to the technical side, as well as the commercial side, as well as the price and risk. So that's what I meant.
Okay, would you accept that if it's true what is in your own company's documentation, and you are representing them, would certainly seem to indicate that there was another process other than the one you've just mentioned, this rigorous price negotiation? Would this seem to be a fair indication that there was actually something else going on as well?
No, I disagree with that.
And what basis could you? I think the plain words themselves, meetings in London. I'm unaware of any part of the acquisition process happening in London, and this Thompson document is clearly about the Corvette Combat Suite as part of the Corvette acquisition.
Mr. Chair, if I may, you may recall that when a number of documents were introduced into the bundle, there were objections from several parties, and I objected at that time. You made a very judicious ruling which allowed the documents to be permitted, but not waiving any party's right to object on the normal grounds of admissibility. And I think you may recall at one stage I objected, well, not objected, but I noted that the potential then arises for parties to speculate and to debate amongst themselves in evidence as to what the documents mean. I think we're finding ourselves in a similar position here, and I don't try to silence Dr. Young. I merely suggest that there would be a more appropriate opportunity in due course, should he want to make representations during the closing argument. This witness cannot take it further, and well, maybe it was a good thing that I didn't object before she gave that direct evidence herself. She's not the author, she was not at the meetings, and she's unable to take it further.
Dr. Young, the point that has been made is that this witness says that I was not at that meeting. Whatever answers that she's going to give us about that meeting, she'll be speculating.
Yes, but she still represents the company whose employees were at that meeting. That's why she's here. Otherwise, she's representing the company who wrote this document.
Dr. Young, my function is to give rulings. Once an objection has been raised, my duty is to give rulings. And I don't expect you to argue with my rulings, particularly on a small point like that one. The witness has said to us that she was not at that meeting. Any further questions that you want to direct to this witness about that meeting, she'll be speculating. And I'm not quite sure whether it will help this commission if we're going to allow witnesses to speculate. But then if you want to insist on that point, the witness can start speculating. But I'm not quite sure if that is going to add any value to the proceedings of this commission. Can I find out from the witness if she's prepared to speculate?
No, Mr. Chair. I cannot speculate.
Okay, on the same point, using a document whichever you've adduced into the evidence, it's at your page 39 of the attached to your own witness statement. Now, clearly, okay, this is an extract out of my own witness statement, but you've introduced this into your own evidence. So, would it be fair to say that it has relevance to your evidence?
Mr. Chair, I would like to beg leave just to address this issue, especially with regard to the statement and the bundle or annexures to the statement. The purpose, I think, in order to can understand better as to which way to go in terms of cross-examination or so, it is important that the purpose for which the documents are attached is placed on record. Firstly, this witness will not be in the position and is not in the position and is not even pretending to be in a position to adopt the evidence of Dr. Young or any other witnesses whose evidence or statements are attached here to. She will not do that, and she's not doing that. The sole purpose for which these documents are attached is addressed by the evidence that has been presented by the witness. Now, the information relating to Dr. Young, be it in the form of a statement or in the form of evidence, is introduced in order to illustrate the point of the criticism leveled in respect of the three topics that I have placed before the Commission. And that is solely the purpose why these documents are there, and not for the witness to try and actually authenticate and even speak about the correctness or otherwise.
Mr. Omaka, I hear and understand where you're going. Let me hear Dr. Young, what he means when he says that, the witness introduced Dr. Young's evidence into the record. Okay, can you just explain to me what does that mean?
Well, by doing so, she has to think that it is relevant in some way.
Doctor, I don't quite understand. You said the witness introduced this portion of your evidence into the record. What did you mean by that?
No, not into the record, into her, because it's already on the record, into her own evidence.
I really can't understand how can she introduce in her evidence part of the transcript. This is already part of the transcript. And as Ms. Ramakaha was saying, these copies were made for the convenience of the Commission so that she can be in a position to address the three issues that she referred to. Not that she was adopting what you were saying. Maybe it might be better if you can really rephrase your question and not say that she adopted part of your evidence.
Okay, I have to learn on the fly here. Okay, but look, just using this document, this page 39 in front of us, would it be correct to say, would you accept that this is a verbatim transcription that came out of a criminal trial where a Thompson employee was giving this evidence? Is that fair?
I'm afraid I think the question's unfair on a whole lot of levels, and particularly under cross-examination. The witness runs the risk of appearing purely to be cooperative. We need to know who the Thompson employee is, and we need to know why she's been asked to confirm it before she can even begin to attempt an answer.
It's clear that Mr. Moineau is somebody that the witness has actually mentioned herself, at least in oral evidence. So I'll just ask her, is Mr. Pierre Moineau, was he an employee of Thomson?
Yes, he was.
Okay. Now, his evidence is that he responded positively to an assertion made by the prosecutor that your, being his and the company's informal contacts with high-ranking personalities would give the edge, as it were, at a high political level. And his response is, that's what we hoped. And the prosecutor says, yes, that's what you hoped, question mark. And Mr. Moineau says, yes, that's what we were going for. Now, would you consider that, if that is true, would you consider that as part of a transparent process?
It calls for a speculation on the part of the witness. I might also say, even though I would probably be straying a little bit, the earlier proposition was that this was at a trial of a Thomson employee, and I gather in the context that the suggestion is that a certain Mr. Shabir Sheikh was an employee of Thomson. And I would put on the record that if the witness was asked to confirm whether Mr. Sheikh was ever an employee, she would have to answer that he was not. So I think the question's unfair.
I think that that's incorrect, because it might not have been an employee of Thomson South Africa. He was a director of Thomson South Africa.
Dr. Yang, maybe let's try and avoid trying to argue with each other. If I'm in charge of the proceedings. If somebody makes a point, if you don't agree with it, then I must give you permission to answer that. If at all we are going to talk to each other across us like this, we will not finish. It was not necessary for you to try and answer the legal representative immediately after he made a point. You wait for us to give you an opportunity to do that. But in any event, coming back to this statement that you have mentioned, what do you expect the witness? Do you want the witness to confirm that this is what happened, or do you want the witness to confirm that she's aware of the contents of this document? I don't quite follow the question.
I just say, if the contention is correct of what is being recorded here as part of the process, would she agree or disagree? Would she still contend that this is part of a transparent process?
I don't really understand the question, but Mr. Moineau was testifying on his own, so I just can read what he said.
Well, what I can say is I think you can read what he said, and the words then speak for themselves. This contacts at high political level was not part of the process, and it was not recorded. It was certainly not transparent.
Chair, it is not.
I just want to propose that maybe in order for us to make some progress, and I'm trying to assist Dr. Yang here, when you look at the statement of this witness, I think the area where she has some kind of personal knowledge relates to the offsets. It appears that that's where she has some personal knowledge. And maybe it might be more useful maybe to rather focus on areas where it appears that she has some personal knowledge. And in my reading of the statement, that area is the offsets. Otherwise, the whole statement is in broad outline, and it's quite clear that she was not involved in the actual processes, the acquisition processes, especially whatever transpired in South Africa. And I think it's not going to help really trying to probe those issues we've had, because she clearly has no personal knowledge of some of these things. Actually, the majority of them, especially matters that transpired in the acquisition process in South Africa. So I'm just suggesting that maybe you might well rather focus maybe on the area that appears that is within her personal knowledge, and that relates to the offsets, if you look at a statement.
Well, with respect, I'd have to disagree that that her own personal involvement only goes around offsets, because her own evidence in chief also it ventilated to a substantial degree her involvement in meeting Dr. Maduna and Mr. Nguka and Mr. McCarthy with Robert Dreeman and Mr. A.J. Suklal regarding the encrypted facts. Those are all to do with, in my view, those have got nothing to do with national industrial participation.
Maybe you should then ask her about encrypted facts because she has testified about it.
Yes, indeed, and that's exactly where I'm going to now.
You see, by way of example, what I'm saying, if you look at this letter that was written by the other gentleman, Mr. Boladier, dated the 9th of July, she's not the author. She's not the author of the letter. And I don't think she even understands the context. She doesn't, I don't know whether she knows that, what role Mr. Sheikh played in the whole acquisition process. And I understood your point, and I knew exactly where you wanted to get to with your questions on this letter. But she's not the author. She can really not be asked about the correctness or otherwise of the contents of the letter. So that's why I suggest that maybe try to focus on the areas where she seemed to have some personal knowledge. You talked about encrypted facts about which she has testified.
I just wanted to refer to the very first page of the witness's witness statement and paragraph 4 there, page 1, right at the beginning. And I suppose I will just maybe read this and they of course allow the witness to confirm whether it's correct, but it's in response mainly to Commissioner Muzi's point, and this is where I'm coming from, is because both according to her own witness statement and the fact that she's representing the sole representative of this company at these proceedings and seems to be authorized to represent the company. But nevertheless, it says, in the capacity for which I am employed, I've had extensive exposure and experience in the arms procurement process in South Africa virtually since its inception. I'm aware of the negotiations and signature of the contract in South Africa from 1998, but at that time was not involved in any detail at all. I became involved in more detail in 2002. But certainly, if her own words are true, is that she's had extensive exposure and experience, and that was where I was coming from in that regard. Nevertheless, if I may go to on a subject which is a legal subject, and the witness has, I think she is an advocate or an attorney. And this is something in the legal domain, and she was personally involved. Regarding the encrypted facts, you testified that you first met Mr. Dr. Maduna and Mr. Nguka and Mr. McCarthy, the latter two from the National Prosecuting Authority in early 2004. Is that correct?
I think I said that I met them in early April 2004, yes.
Yes, I have a date in my mind of the 5th. It's either the 5th or 6th of April. That would accord with that. You also testified that you were shown the encrypted fax, the crumpled up version written in French. Is that correct?
Just a point of correction, Chair. The witness did not say that she was shown an encrypted fax. She said she was shown an alleged or a document that is described as an encrypted fax. So she did not describe it as a fact that it was in fact an encrypted fax. And this, the witness has consistently described the document as such. So it's just a point of correction on how she characterized the document.
I think we'll get to that point.
If at all you put an incorrect statement to a witness, the legal representatives are entitled to correct you. I also remember the witness never said that it was an encrypted fax. She said that an alleged. So those two concepts are totally different. And once you have been corrected for putting an incorrect version to a client, please do not display the type of attitude that you are displaying by saying that no will come to that. You must consider that was not correct. This is not what the witness said. And I'm sure in that way we'll be in a position to make progress. You can proceed with a cross-examination.
Thank you. Okay, is it correct that you were shown a piece of paper written in blue, written on both sides, written by Mr. Tetard?
I was shown a document which was unwritten, and it was blue ink, and it seems that it was written by Mr. Tetard.
Okay. Were you given a copy of? Were you given copies of this or not?
I don't remember, but I think I have a copy of this document. I have had a copy of this document for quite a long time. Yeah.
Yes. So you have been in possession of it for a substantial period of time. Okay. If we may we use the English version of it? That's at page 61.
Yes, I have that in front of me.
Okay. On the third paragraph, it starts with may I remind you that the main two objectives of the effort, quotation mark, requested of Thompson are. Is it correct that your evidence was that your interpretation of this was that this was a request for money by Mr. Sheikh?
That wasn't the evidence. I suggest that all that the witness was able to testify was to two things. Firstly, that she disagreed as a matter of fact on the translation from French to English. And secondly, what she was able to say was that she could submit a statement by the author as to what he said it meant. The witness wasn't the author. She can merely report that. I may also mention, And it's true that this was included. It was included because my client's thinking was that even though this is outside the terms of reference of the Commission, allegations have been made of a serious nature, and my client should attempt to deal with them. So that's not being swept under the carpet, but the way this question is being asked is overly broad and is not putting to her the propositions of the evidence she gave.
Can you try again, Dr. Young, try and put a proper proposition to the witness?
Okay, just on the pure words of it. It would seem, and I'm asking, is this a fair summary of it, is that this document is requesting something of your company, which you represent. It's requesting that what they call an effort is supplied by a recipient of this transaction. Is that correct?
I have difficulties to understand the question. Maybe you can rephrase it.
No, I'll just carry on. Okay, the next line is those two efforts that are being identified by the author, Mr. Tattard. I just want to ask you, are you aware of the meaning of the word citron?
I know it was the name of the project of selling, purchasing from the name of the project.
Yes, that's the correct. It's the name, the code name in South Africa for the Corvette project. Okay, were you aware at the time, and you must have been from what you've testified regarding your meetings with Dr. Maduna and Mr. Bulelani Nguka, that there were investigations that describes current investigations where more in the time frame of this document, let's say early, I think this thing was sent in 11th of February 2000. In that time frame, it was well known in the public domain, even in the media, that there were investigations. Would you not have known that at that time?
Mr. Chair, just on a point of clarification, the witness has consistently said that she did not know that the document was ever sent. But it's not going to aid things one way or another if the witness attempts to answer this question, which she can't. She can't answer it. It's a different question asked in relation to a document. And perhaps it would be easier if we just moved from the document and the witness was specifically asked if she was aware in February 2000, if that will assist.
Maybe let's allow the witness to answer that one. If I understand Dr. Young, he says it was well known, it's been in the media. I'm not sure whether when he says in the media, he refers to the South African media or to a French media. Maybe if you can explain that, because mind you, the witness said that I'm a French citizen.
Yes, I'm certainly aware of documents, and I have them. There were a number of facsimiles from South Africa, from Alain Tattard, and back to head office in France, with copies of press articles written about the arms deal investigations. And one would have thought that if the witness was involved at this time, especially as a legal representative, would have been aware of them.
Dr. Young, can you get on with the question?
Okay, but my main point is here is that this document clearly describes one of the efforts as protection for Thompson during the current investigations. Now, at the risk of speculation, but it has to, what possibly, and you are the legal representative of Thompson, what possibly, in the light of transparent acquisition process in Project Citron, could Thompson require protection from investigation?
Just, generally I'm a person that does not like raising objections. It's just that I'm compelled to in the circumstances. Firstly, Chair, the witness says the document clearly shows that there was a request for protection. I beg your pardon, not the witness, but Dr. Young. He says this in the face of evidence from the witness that, firstly, she does not agree with the interpretation, the English version. And this is even bolstered by the author of the document, Mr. Tettard. In his affidavit, he says, I do not agree with the interpretation. It is not the correct version of what is being said. Now, in the face of that, can you say, relying on this document whose interpretation is questionable, it is clear that it is saying the following? Where is that clarity drawn from? I can see that the commissioners are at pains to try and guide the cross-examiner, and that is highly appreciated. I don't know how else you should communicate, but, well, because if the cross-examiner is to understand you very well, I will sit back and not object again, because the necessity will be dispensed with.
Mr. Mahar, may we sit back and don't object again? I understand the point that you're making, and I think this is a point that I made right at the beginning. But then the witness is a lawyer. If she wants to speculate, she can continue speculating. Do you want to speculate? If you want to speculate, continue speculating, because you're not giving us direct evidence. Whatever answer that you're going to give to the question that has been put to you now, you will not be giving us facts, but then you'll be giving us your opinion. You were not at that meeting. You'll be speculating. But then if you want to speculate, you can go ahead and do so.
I don't want to speculate. I'm not the author of the document, and I just can't read what is written.
Yes, but you were deeply involved in this issue with Mr. Tettard and all the subsequent affidavits and the interaction with Mr. Dreeman and Mr. Suklal and Dr. Meduna. So you were intimately involved with this, and you've had this document for a long time. Is that correct?
I have been involved, yes, but I've not been the author of the documents, and I cannot speculate about things I don't know.
I'm just really asking you, from a Thompson representative and a Thompson legal representative, for your view on a document written by a Thompson employee.
I think the one who can speak about this document is the author and could explain what he meant when he wrote it.
I think that the author of this document refuses to come back to this country. That's a reasonable statement. Is that true or not?
May I just put this in perspective, Chair? The author of the document, as I understand the evidence thus far, the author of the document that Dr. Young is seeking the witness to respond to is not Mr. Tettard. From this English version, it's a document that is described as an interpretation by someone from the High Court of the Good Hope, if one reads at the bottom of that document. So will it really be fair for someone to say, but let the author of this document come back from wherever he is? Where is this author of the document who says he's interpreted it and he's from the Cape of Good Hope as a translator?
Dr. Young, do you want to respond to that?
May I just continue what I believe is a relevant line of questioning?
Dr. Young, I'm in charge. I'm going to determine what is relevant and what is not relevant. What I'm asking you to do is whether you have any response to what Ms. Ramachara is saying.
Yes, I didn't hear everything, so Mark wasn't on all the time. But maybe I just need to state that it seems to be both Attorney Ramagaga and the witness's position that this document is simply a document that it was the one that is just a translation. The translation wasn't written by the author; it was typed by somebody else. But I just need to state in perspective that this document was used in a criminal trial of somebody who was a Thompson director. His name is Shabir Sheikh. And it was accepted into evidence at the trial court in Durban, the Durban High Court, and even via objection from the defence, it was accepted into evidence by the trial court, and that was taken on appeal to the Supreme Court. The Supreme Court also found the document admissible and to mean what it means. So, if I may just state, and maybe we can leave it at that, is I'm looking at a copy of the Supreme Court judgment here.
Don't worry, we have seen the judgment. We're all aware of the judgment. Just make the point that we wanted to make. Maybe don't try and give us a legal lecture. We are all aware of the judgment. What point do you want to make?
You asked me to respond to Attorney Ramagaga, and certainly what came across to me there is that this document is just something that has dubious relevance or admissibility, but it's actually far, far higher than that. It was the prime piece of evidence used in count one on finding Shabir Sheikh, a director of Thompson, guilty, and that was confirmed by the Supreme Court of Appeal. So this document certainly has substance, it has gravitas, and maybe like I say, that could be a question: is that statement accepted or not?
Dr. Young, we're not going to answer questions from you. Maybe let me just find out from the witness. Do you know anything about this document? The one which is at page 61 that Dr. Young was asking you about?
I've seen that translation, but it's not the original document that I've seen, so it's...
May I ask the witness, are you aware or not aware that this was a primary piece of evidence used in a criminal trial in this country?
Yes, I know that it was used during the Shabir Sheikh's trial.
Do you know that despite the objections that it was deemed admissible by both the High Court and the Supreme Court?
I would have to read back the judgment. I haven't read for a while.
With your permission, Chair, may I just read one sentence here from the Supreme for the benefit of the witness?
Okay, Dr. Young, you can proceed. You can go ahead.
The Supreme Court of Appeals judgment in this regard states as follows: at the trial, the defence objected to the facts being admitted in evidence. The trial judge ruled it admissible on a certain ground. We took a different ground, that the facts is indeed admissible. Would you accept that that is true?
I assume that the sentence you read is true.
And if that is all true, tested in the High Court and the Supreme Court, would you not accept that the contents of the facts, whether it's the original handwritten version, okay, it wasn't okay, I agree, it may not have been a fax at that stage, it was typed, and then it was faxed through this encrypted facsimile, and then of course later it was formally translated. If that is all true, would you not accept the relevance of that as evidence regarding a director of Thomson CSF?
I disagree with you on many counts.
Well, could you just state the first most important one?
First,
Dr. Young, I'm not quite sure where this cross-examination is taking us. Whether she accepts this document, she doesn't accept it, or whatever views that she might be having about this document, whether she thinks that there's proper evidence or not, I'm not quite sure how that is going to help us. Because at the end of the day, she's not going to make the decision. Whether she accepts these documents or not, to me, is irrelevant. She might just say, okay, I accept it, what you're saying is right. This is what the Supreme Court of Appeal said. How does that help us? What? In her answers, how does that help us?
In my view, it is.
We know that what you're saying, this is what the Supreme Court of Appeal said.
You see, in my view, the witness and supported by Attorney Ramagaga have basically, I'm not quite sure if this is the right term, have rubbished the veracity or the contents of the encrypted fax, using the generic, the colloquial term for it. Yet at the same time, they say that both of them. Yet at the same time, it first of all refers to the conduct of Thomson, and secondly, it seems to be second guessing the High Court and the Supreme Court in this country. That is my position.
Dr. Young, I can promise you now, I'm not long going to interrupt your cross-examination. You can continue now.
Thank you. We're getting very close to the end. I just wanted you to turn to RMY 67 on the bundle of two documents that was given to you. Okay. Would you confirm that this document, in what language is this document?
It's
in French. Which one on the page?
The document. There is a translation also.
Yes, that's correct. And could you identify the name of the document?
I must say that's the first time I've seen this document, and it appears to be a document describing a project Citron.
Yes, so would you say that is a reasonable inference that it refers to the Corvette program?
Yes.
And in reference to Afrique du Sud, so the South African Corvette program?
Yes.
And it seems to indicate on the face of it that it is in respect of your company, Thomson CSF, NCS, Naval Combat Systems of France. Is that correct?
I don't know because there are two companies. In fact, there is ADS and Thomson CSF and CS France on the document.
Yes, that is correct. But would you agree that it's those two companies that collaborated in order to provide this most competitive bid for the Corvette Combat Suite? Is that a fair way of describing the relationship between ADS and Thomson NCS?
Yeah, I think they were working together to put an offer for the combat suite system.
Yes. Okay, and the title of the front page in French describes it as a système de combat pour Corvette in 4. That's 4 Corvettes. Is that correct?
Yes.
Can you see a date written on that?
I can't really read the end date. There is an unwritten date, but I'm not sure that it's contemporaneous.
No, I just asked you, can you see a date written there? Not what the meaning for. I can see a date. Can you not see a date?
Sorry, I don't understand.
I said, on my copy, I can see a date just to the left-hand side and slightly below the word pour.
There is a date, an unwritten date, which is 28 January 1999.
Yes. Now, you were involved in this process, according to your witness statement. Can you remember what the state of this acquisition process was at that time, the 28th of January 1999?
As I told you, the end date. There is an unwritten date, but I'm not sure that it's contemporaneous.
No, I just asked you, can you see a date written there? Not what the meaning for. I can see a date. Can you not see a date?
Sorry, I don't understand.
I said, on my copy, I can see a date just to the left-hand side and slightly below the word pour.
There is a date, an unwritten date, which is 28 January 1999.
Yes. Now, you were involved in this process, according to your witness statement. Can you remember what the state of this acquisition process was at that time, the 28th of January 1999?
As I told you, I was not involved into the detail of this acquisition program, but from what I understand, the contract was signed in December 1999. So it was a process of putting together an offer, I think.
Yes. If I said the preferred suppliers were selected in late 1998, and then a process initiated, as you correctly say, of the negotiation towards a contract that started in middle December 98 or early January 99. Would you accept that?
I have to take that assumption that it's correct.
Very good. And underneath the date there, can you see some scribbling? Looks like an arrow and initials of somebody.
Yeah, it seems there are some initials, but and words as well, which is amicalement.
Yes, I'm specifically also interested in the word in brackets after the initial AT. Could you tell me what that means?
It's mean encrypted, meaning that it would be sent through a encrypted fax machine.
Yes, thank you for that. Yes, could you go now to page 1344, about halfway through that document? Would you agree or disagree that it seems on the face of it to emanate from the National Police Directorate of the Republic of France?
I cannot agree with that because I would have to see the original version if it exists.
Okay, I can't seem to find the French original version of it, but I can assure you it does exist. But all I'm asking to say is, on the hypothesis that it is a genuine document, would it seem on the face of it, that's all I'm asking is, on the face of it, would it seem to derive from the French police department?
Cannot speculate.
Okay, I think if I may observe that this is not that difficult to do for somebody. We can see down the left-hand side what I understand to be the mark and the signature of the translator. But if we have to do it, we'll have to have another break. And while I find a French equivalent of this, but be that as it may, I, for the record, would like to indicate that. Unfortunately, I was confronted with a situation where I only knew this witness was appearing today. That's a pretty short time. I would certainly have ensured that the relevant documents were available for me and for the Commission. But I think I did a reasonable attempt at this in the time that was available. But nevertheless, if we go down halfway through the page, would you care to read what the English translation is? I understood from the very end of your evidence that you said that nobody from no person, and that means both a natural person or a juristic person, had ever been charged in this country regarding a Project Citron combat suite acquisition. Would you agree that he was a Thompson director and he was charged with a crime relating to the Corvette?
First of all, he was not a Thomson director in the way that he was not an employee of Thomson. He was appointed by his company as being a director because of his shareholding. which is completely different.
No, well, he was a director of Thomson. Would you agree or disagree that he was also a director of ADS at one time?
I can't recall, but it may have been.
Yes, and he was a director of ADS, and certainly at some stage ADS was 100% owned by Thomson. Is that correct?
I would have to look at the records of the company. I don't know on top of my head when was that, what's the timeline of this event that you are referring to.
Okay, but that should be a sheikh and a director. Are you aware of no other, I'm not talking about employee, but a juristic person, which is a company, an incorporated company, also being charged with a criminal charge relating to the Corvette?
There has been charged, but charges were withdrawn.
Yes, but it wasn't that what your evidence was, that nobody was ever charged. Is that correct or not?
Well, I think if the question was put properly, it would have to refer to what the indictment in that in that prosecution said. The witness is being asked to speculate. These were complex things, and as no one's trying to walk away from answering questions properly put, but the matters of complexity, and it would be.
Okay, but that should be a sheikh and a director. Are you aware of no other charge relating to the Corvette?
There has been charged, but charges were withdrawn.
Yes, but it wasn't that what your evidence was, that nobody was ever charged. Is that correct or not?
Well, I think if the question was put properly, it would have to refer to what the indictment in that in that prosecution said. The witness is being asked to speculate. These were complex things, and as no one's trying to walk away from answering questions properly put, but the matters of complexity, and it would be unfair to put to the witness without disclosing exactly what in the indictment referred to the combat suite.
The juristic persons within the Thomson Group relating with charges relating to the Corvette.
I'm not sure that I understand your question, because from earlier you talked about the combat suite, and as I told you, they have been charged against some of the company, but they were not specific to the combat suite.
Well, unfortunately, there wasn't sufficient time to make copies of all this, but I have copies of both the indictment and the summary of substantial facts in terms of Section 1443 of the Act 51. And the parties to this indictment are one, Mr. Jacob Zuma, two, Thint Holdings, accused number 2, and the other, I think it's Thint Pty Limited, accused number 3. Would it not, in that case, be reasonable to ask whether if that's true, that subsidiary companies of Thomson or Tali's have been served an indictment in this country for criminal activities?
They have been served, I agree with you.
Would you also disagree that at least one of those charges directly involves the Corvette, the acquisition of the Corvette combat suite?
I would have to read the document. I can't recall right now.
Well, again, in the shortness of time, all of these documents were not copied for the witness and for the Commission. But I think it certainly in South Africa, it has to be common cause that what I'm stating is true. Okay, that concludes my cross-examination.
Thank you, Dr. Young. Any re-examination? I'm not quite sure what should do or what I should do, because at the beginning I was saying that evidence leaders are not supposed to re-examine, but I may normally insist that they're entitled to re-examine. Maybe I'll start with the legal representative of the witness first, and from there, then the evidence leaders.
Thank you, Mr. Chair. Just one question. Ms. Guerrier, the document in your witness bundle at page 58, which you have given evidence, is a copy of a document which you've seen before. You gave evidence that you caused investigations to be made.
Maybe let me say to the witness, thanks a lot for coming out and coming and testify. We really appreciate